But in her speech, Judge Sotomayor explains, quote, the nature of the criticism of using international law comes from a misunderstanding of the American use of that concept of using foreign law, and that misunderstanding is unfortunately endorsed by some of our own Supreme Court justices. Both Justice Scalia and Justice Thomas have written extensively criticizing the use of foreign and international law in Supreme Court decisions, close quote. So she criticized Justice Scalia and Thomas, who have expressed opposition to this. Let me be blunt. I believe it's Judge Sotomayor, not the Justices Scalia and Thomas, who are wrong. Under her approach, a judge has free rein to survey the world to find what they might consider to be good ideas, and then impose these views on the American people, calling it law. However, this is not the American system. Our system requires judges to adhere to this Constitution, to the statutes, and to the legal precedent, to the end that judges follow the will of the people of our country as expressed in our law. The Constitution says we do ordain and establish this Constitution for the United States, not some other. Judges aren't free to amend it by citing some other foreign constitution. I think this is a big deal. So judges aren't free to indulge their own personal opinions about what good policy is. Judges don't set policy and to search for support for that in foreign law. Despite Judge Sotomayor's claim at a Duke Law School panel discussion that, quote, courts of appeals is where policy is made, close quote, judges are not policy makers. They are servants of the law if they're fulfilling their role properly. The law as it is, not the way they might wish it to be. Second, reliance on foreign law causes confusion rather than clarification as to the state of American law. Judge Sotomayor claims that foreign law, quote, can add to the story of knowledge relevant to the solution of a question, close quote. Paraphrasing Supreme Court Justice Ruth Bader Ginsburg, who pioneered this concept, she made those statements. And Judge Ginsburg's citation of it in cases and her defense of it in speeches has really led to this controversy in which Scalia and Thomas have responded. So on the contrary, reliance on foreign law creates confusion. Consider Sotomayor's dissenting opinion in Kroll versus Kroll in the interpretation of a treaty, one of the few instances in which reliance on foreign law may be perfectly permissible. Judge Sotomayor repeatedly criticized the majority judges on the panel as parochial for consulting American dictionaries to understand the meaning of custody as determined by the Hague Convention on International Child Abduction, and then she relies on foreign interpretations of those words instead. Yet the majority rightly rebuked Judge Sotomayor for relying on the scattered and divergent foreign legal cases on this subject. The majority even cites the Supreme Court precedent that warns against relying on foreign law where it's in a state of confusion. Third, the reliance on foreign law is also based on a misconception that judges, rather than elected officials in the political branches of government, play a role in advancing our nation's foreign policy. Judge Sotomayor states this, quote, I share more the ideas of Justice Ginsburg and her thinking that unless American courts are more open to discussing the ideas raised by foreign cases and by international cases, that we're going to lose influence in the world, close quote. But judges aren't diplomats. It's a job of diplomats to protect our standing in the world, and they have to explain to the world why we rule the way we rule. on our cases. That's their responsibility. Fourth, reliance on foreign law blurs the distinction between domestic and foreign law, undermining our ability to make democratic choices. The examples of the Supreme Court reliance on foreign law, cited approvingly by Judge Sotomayor, involve the interpretation of the Constitution dealing with purely domestic legal issues that do not and should not touch on any matter of international concern. For example, she approvingly cites the case of Roper versus Simmons, in which 5 justices of the Supreme Court recently rendered a decision based in part on their review of foreign law and concluded that our Constitution declares that we cannot execute a violent criminal if that criminal is one day under 18 years of age when he killed someone or a group of people. There's nothing in the Constitution that says that. They found some foreign law to make an argument about what the Constitution says about what age a state can set for a death penalty. Now, I know we can disagree on what the age should be, but it's a legislative matter. The court in that case said it was looking to, quote, evolving standards of decency that mark the of a maturing society, close quote. Well, that is, what kind of standard is that for law? Where do you find what the a maturing society now believes? Do you check with China? Do you check with Iran? Or maybe France? I mean, where do we do this? How do they define what this all is? The court concluded that the death penalty violated the 8th Amendment, which prohibits cruel and unusual punishment, when there are at least 6 or more references in the Constitution itself. The capital crimes, to not taking life without due process. It's always been contemplated in the Constitution that the death penalty is not cruel and unusual. That was for drawing and quartering and such matters as that. If basic constitutional rights are subject to redefinition by considering foreign law, our Constitution ceases to be the bulwark for our liberty it has always been. The Constitution will be weakened. Its authority and power will be diminished. Yet this is precisely the view of foreign law advocated by Judge Sotomayor.
Death of a 50-year-old, of any 50-year-old